Thank you, Professor Sidagi. Thank you, all gentlemen here. Thank you, colleagues. Dziękuję. It is a great honor to present a few reflections on the principle of automatic recognition of foreign judgment in civil matters after more than 15 years of Polish experience. The Polish reform that entered into force on 1st of July 2009 replaced the traditional model of prior judicial recognition with a rule under which foreign judgment in civil matters are, as a matter of principle, recognized by operation of law. This reform was one of the most important developments in Polish private international procedural law after 1989. It is therefore worth asking, after a decade and a half of practical application, whether that solution has fulfilled its promises and what lessons may be drawn from it. My main thesis is a balanced one. The reform was directionally correct. It reduced formalism, simplified many non-contentious situations, and better adapted Polish law to the realities of cross-border family, personal, and commercial relations. At the same time, it did not eliminate the need for control. It merely shifted that control from a mandatory, prior, and centralized judicial review to a subsequent, frequently dispersed, and often more difficult form of examination. In that sense, the Polish model of automatic recognition should be maintained, but its practical framework still requires refinement. Let me begin with the basic point of comparison. Before 2009, Poland followed the traditional deliberative model. A foreign judgment did not, as a rule, produce legal effects in Poland unless a Polish court had first recognized it in separate proceedings. That model provided formal legal certainty. The court examined the admissibility of recognition before the foreign judgment entered the domestic legal order. But this certainly came at a cost. Even in simple and undisputed cases, parties had to initiate separate proceedings merely to confirm the effectiveness of a foreign decision. That was burdensome, time-consuming, and often unnecessary. The 2008 reform changed the architecture of the system. Under Articles 1145 to 1148 of the Polish Code of Civil Procedure, a foreign judgment in a civil matter is recognized automatically, unless one of the statutory grounds for refusal applies. This means that the point of departure is no longer distrust, but conditional acceptance. The foreign judgment is presumed capable of producing effects in Poland unless there is a serious legal reason to deny it. This shift corresponds to the growing intensity of cross-border legal life and to broader European tendencies favoring circulation of judgments. The advantages of this reform are substantial. First, the reform reduced formalism. Parties no longer need to initiate a separate recognition procedure in every case. In many family and status matters, as well as in ordinary civil disputes, this has made legal practice considerably simpler. A foreign divorce judgment, a judgment concerning civil status, or a civil liability decision may in principle operate in Poland without an additional constitutive ruling. Second, the reform better reflects the realities of modern legal circulation. Foreign judgments are no longer exceptional documents entering a closed domestic system. They are part of the ordinary legal environment of a mobile society. The old model treated treated foreign judgments as if they required formal admission in every case. The new model accepts that many such judgments are uncontroversial and should not be burdened by an additional layer of litigation. Third, the reform is conceptually more coherent. Recognition is no longer understood as the creation of a new domestic legal effect by a Polish court, but as acknowledgement of the effects of a judgment already rendered abroad. This is theoretically significant. It aligns the legal construction more closely with the practical nature of recognition, which is not the issuance of a new judgment, but the acceptance of an already existing one. Fourth, the reform preserved a safety mechanism. Automatic recognition does not mean unconditional recognition. The Polish legislature retained grounds for refusal, especially those relating to finality, the right to be heard, and public policy. Moreover, Article 1148 of the Code of Civil Procedure allows any person with a legal interest to seek a declaratory ruling that the foreign judgment is or is not subject to recognition. So the reform did not abolish judicial control altogether. It made that control secondary rather than primary. However, the disadvantages and practical weaknesses of a current model are equally important. The first weakness is dispersion of review. Under the previous system, review was centralized in one judicial procedure. Under the present one, the question whether a foreign judgment is effective in Poland may arise in court proceedings before a notary, in land and mortgage register practice, in company registration matters, or before civil registry authorities. The same legal issue may thus reappear in many institutional settings. This creates the risk of uneven practice and different practical thresholds of caution. The second weakness concerns finality. It may seem obvious that only foreign judgments should be recognized, but in practice, proving finality is not always simple. Different legal systems conceptualize finality differently. Sometimes additional certificates of further explanation of foreign procedural law are required. Thus, automatic recognition simplifies the procedural form, but it does not eliminate evidentiary and classificatory difficulties. It moves them elsewhere. The third practical challenge is the right to be heard. This remains one of the most important grounds for refusing recognition. A state cannot accept as effective as foreign decision rendered without ensuring that the defendant had a genuine opportunity to defend his or her rights. The difficulty lies in the fact that the service of process across borders is often complex. It may involve foreign procedural law, international conventions, substituted service, language issues, or uncertainty about whether the party actually had a meaningful chance to participate. In such cases, the promise of simplicity recedes, and one is confronted with demanding review, even under a formally automatic model. The fourth difficulty concerns the public policy clause. This clause is indispensable, but dangerous if misunderstood. It is indispensable because it protects the fundamental principles of the domestic legal order. It is dangerous because an expensive understanding of public policy could turn automatic recognition into a hidden mechanism of merits review. The Polish discussion shows clearly that public policy must be interpreted narrowly. It is not enough that the foreign solution differs from Polish law. What is required is a qualified contradiction with fundamental principles. Without this restrictive approach, the entire logic of automatic recognition would be undermined. A particularly illuminating field is that of judgments originating in legal cultures different from the mainstream continental European model, especially religious adjudication. The Polish discussion rightly emphasizes that not every decision issued by a religious body can be treated by the same way. What matters is not simply the religious character of the body, but whether, under the law of the state of origin, it forms part of the state judicial system and whether its rulings produce civil law effects. This is why Israeli rabbinical courts may, in principle, be treated differently from Sharia councils or Beth Din bodies operating in Western Europe. If a religious court functions as a part of the state judicial framework, its decisions may potentially fall within the notion of a foreign state court judgment. If it is merely a communal, religious, or arbitral structure, the situation is different. The example of talaq divorces makes the issue even more complex. Classical talaq may be clearly problematic from the perspective of Polish public policy because of its unilateral and gender asymmetrical nature. Yet, even there, the analysis cannot always be mechanical. Scholarship has argued that in some circumstances, particularly where the connection with Poland is weak, and the parties have already reorganized their lives, refusal of recognition may create consequences more harmful than recognition. This demonstrates a very important feature of the Polish experience. Public policy is not a slogan. It is a serious instrument requiring individualized and context-sensitive reasoning. This leads me to another important practical issue, so-called limping legal relationship or limping civil status. A person may be considered divorced in one state and still married in another. A child's status, the existence of a marriage, or the effects of a foreign family judgment may differ across jurisdictions. One of the major advantages of automatic recognition is that it reduces the risk of such fractured legal situation. If recognition required prior constitutive judicial intervention in every case, the persistency of contradictory personal statuses would be more common. The reform, therefore, serves not only procedural economy, but also the stability of individual life situation. After 15 years, what overall conclusions should we draw? The answer should be neither triumphalist nor pessimistic. The reform succeeded in its essential purpose. It removed many unnecessary procedures and made Polish law more responsive to cross-border life. In that sense, the principle of automatic recognition has proved its worth. There is no convincing reason to return to the old mandatory deliberative model as the general rule. At the same time, the reform remains institutionally unfinished. It requires stronger practical support. More uniform standards are needed concerning documents, translations, proof of finality, and the practical operation of declaratory proceedings under Article 1148. More attention should also be given to empirical research. We still lack a sufficiently broad statistical and practical picture showing where recognition disputes arise most frequently and how the various authorities actually handle them. There is also the lege ferenda implications. First, the public policy clause should remain narrow, but its practical standards should be further clarified in case law and scholarship. Second, Article 1148 should be strengthened in practice as a real stabilizing mechanism, not merely a theoretical option. Third, better guidance should be developed for courts and authorities dealing with foreign judgments outside classic recognition litigation. Fourth, the classificatory question should always come first in case involving religious bodies. Are we dealing with a judgment of a foreign state court, an arbitrary award, or merely a religious act without civil effect? Finally, a more active role of public prosecutor may sometimes be justified, especially where the public interest requires a judicial determination whether a foreign judgment should or should not be recognized. Let me conclude in the following ways. The Polish experience after 15 years shows the automatic recognition is not a perfect mechanism, but it is a mature and defensible one. Its value lies in replacing routine formalism with conditional openness. Its weakness lies in the fact that legal certainty is sometimes achieved later, less visible, and through dispersed institutional channels. But that is not a reason to abandon it. It is a reason to refine it. Automatic recognition should therefore be maintained as the foundation of Polish law in this area. The task now is not reversal but improvement, better doctrinal precision, better practical coordination, and better awareness that in a world of mobile persons and mobile legal effects, recognition is no longer an exception. It is a part of ordinary civil justice. Thank you very much.